What are your legal responsibilities when it comes to minors? Not quite sure? Well, grab a seat and watch along with this video brought to you by New South Wales Health as we discuss your complex legal duties in paediatric care. Consent to medical treatment. An easy answer, right? Maybe not, as medical treatment involves the intentional action of physical force upon a body, and without the valid consent by an adult or even a minor, it could be considered assault or battery against the law. Fortunately, the law affords you legal protections against claims of assault and battery depending on the minor's age. Section 49 of the Minors Property and Contracts Act 1970 establishes consent for the medical treatment of a minor. If a minor is aged 14 and older, consents to their own treatment and demonstrates capacity to understand the health concern, treatment consequences, and potential risks, you can rely on their consent as a defense to claims of battery or assault. Additionally, the common law decision of Gillick established the mature minor principle that a child's capacity increases in maturity alongside their capacity to make informed decisions, whilst the authority of their parent diminishes accordingly. Properly assessing consent from a mature minor aged 13 and under is crucial, as legal protections may not apply in such cases. You must decide on a case-by-case basis and consider factors such as the patient's age and maturity, level of independence, seriousness of treatment, and level of understanding and intelligence. When dealing with a mature minor, you use the Consent to Medical Treatment Adults and Mature Minors form provided by New South Wales Health. Otherwise, for minors, you use the Consent to Medical Treatment Minors form and require the consent from guardian, parent, or the court. However, even with your assessment of a patient as a mature minor, the parents may take their medical decision to court in hopes to intervene and overrule. This is due to the shared authority concept established in the case of Marion, whereby both the child and parent have the authority to consent during the transitional period between the patient's childhood and adulthood. Furthermore, as highlighted in the case of Sydney's Children's Hospital Network against X, the fact that you have determined a minor is mature will not prevent the court from authorising necessary medical treatment that is in their best interests, although this is done sparingly and cautiously. Exceptions. The case of Kelvin established that certain special medical treatment requires consent from the New South Wales Civil and Administrative Tribunal, NCAT, for minors under 16. Failure to obtain consent may risk your career, but also potential imprisonment for up to 7 years. Section 175 of the Care Act confirms special treatment includes procedures resulting in permanent infertility, some contraceptive or menstrual regulation treatments, prolonged use of addictive drugs, experimental procedures that are not compliant with ethical guidelines, and other treatments specified by regulations as special medical treatments. But what in cases of emergency? Under Section 174 of the Care Act, no consent is required from any party, whether that be parent, court, or minor, where you believe the minor's condition is a matter of urgency and treatment is necessary to either save their life or prevent serious damage to their health. Substituted decision-making. Substitute decision-making may occur if a minor under 16 years old lacks capacity, known as guardianship. NCAT appoints a substitute decision-maker for individuals aged 16 and above with insufficient capacity under specific circumstances, such as having no suitable informal decision-making arrangements, where there is conflict, an objection to decisions being made and thus putting the patient at risk, or legal reasons. A substitute decision maker for health and lifestyle decisions includes a personal responsible, an enduring guardian, a private guardian, or the public guardian. Parents are examples of a person responsible, and you have a legal obligation to respect and adhere to substitute decision-making arrangements when healthcare decisions are being made on behalf of their children. The Care Act aligns with the United Nations Convention on the Rights of the Child, emphasising treatment decisions must prioritise the child's best interest. Thus, your role involves guiding decision-makers, deciphering medical language, and ensuring treatment minimises harm while maximising the patient's well-being. Confidentiality and privacy. It is established in the Code of Conduct for Doctors in Australia that medical providers are expected to hold personal information about patients in confidence, unless it is required or permitted otherwise by law. However, does this apply for children? Short answer is yes. The Privacy Act also applies to children provided they are determined as competent to consent to medical treatment. Otherwise, parents with capacity would be entitled to their child's healthcare information if the child is unable to provide consent. There are also exceptions in your duty to confidentiality, including where the minor consents to disclosure, when disclosure between other medical practitioners is necessary to treat the patient, or when compelled by the law. You are also required to notify legal authorities in the following circumstances: providing the blood alcohol levels of a patient following a motor vehicle accident, when evidence of a notifiable disease is found, in cases of public interest where you are made aware the patient has committed or will commit a serious criminal offence, when in the best interest of a patient. As under Section 25 and 27 of the Care Act, you are legally obliged to report a minor aged from 0 to 15 when you have reasonable grounds to believe they are at risk of significant harm. However, it is up to your discretion whether to report where the patient is aged 16 to 17 or when unborn. You should take all necessary steps to ensure the privacy during medical examinations and treatments. However, when you are obligated to break confidentiality, you should talk to the minor beforehand when possible to explain what you will share, who you will tell, and why. The New South Wales Health Records and Information Privacy Act 2002 grants all patients, including minors or their consenting parties, the right to access their health information. This applies to both the public and private sectors, imposing a legal obligation on you to respond to the minor's request promptly, ensuring accuracy and relevance without undue delay or expense. Once you have taken a minor's health information, you are obliged to, as soon as practicable, take the reasonable steps to ensure the minor or the consenting party is aware of the following: your organisation's identity and contact details, the purpose of the information collection, their rights to request access to information, recipients of typically disclosed documents, relevant laws mandating information collection. My Health Record. What is it? Minors may have digital health records overseen by their parents who act as authorised representatives. Until the minor either takes control, typically at the age of 14 or older when they have the legal capacity, or when they reach the age of 18. It is important to ensure your patient is aware of their ability to not upload specific information or opt out of uploading pathology results and prescriptions on their record, provided they have the capacity. In conclusion, when treating minors, it's crucial to acknowledge their evolving capacity and the shared authority with their guardians. In cases of incapacity, encouraging the minor's involvement and respecting their views is critical. Guiding all parties through the medical process ensures informed decisions are made and that they are in the best interest of the minor. Thank you for watching.